My Lords, might I just say this? This matter has sparked a lot of interest. In fact, one of the authorities were I required to take matters much further would be that of Mr. Chishonga, the matter of Chishonga. You might be well aware, versus the Minister of Justice, which has become a bit of a locus classicus in protected disclosures matters, more particularly for the finding there of the court, my Lord, that the applicant doesn't bear the onus of proving his bona fides. Rather, it's a matter of what the court concludes on the facts. Now, Mr. Chishonga is, in fact, just for your information, online observing these proceedings. There are two other persons who've taken a lot of interest in the matter. The other is Miss Wendy Addison. You'll recall that in 2000, around there, she brought down, through her whistleblowing efforts, the Leisure-Net Limited, which has been suggested to be the biggest corporate collapse of the decade 2000. In her case, my Lord, she had to flee to the United Kingdom after death threats. And then the job she took there, when they found she was a corporate whistleblower, they terminated her employment, and she had to return here. My Lord, while the objectives and ambitions of the Protected Disclosures Act are highly commended, my Lord, the experience of whistleblowers is always very, very different. And in fact, that has been addressed in certain authorities.
Sorry to interrupt you, Mr. Willis. Just to interrupt you. Sorry to interrupt you. The question of whistleblowing was before the LPC. The LPC had to make a decision whether they were going to regard the actions of Mr. Crichton as such that they should be investigated and with the right to filing a complaint. They obviously came to the conclusion that that was not the case, and I'm certain that whistleblowing was uppermost in their mind when they investigated this matter, because it not only concerned Mr. Crichton, but it concerned a member of the profession who was his principal very much indeed. And as I understand the situation, that is still being dealt with and has not been finalized. So I don't think we are called upon to say anything about protected disclosure or whistleblowing other than what is contained in the papers.
Yes.
And the actions of the LPC in not regarding Mr. Crichton's action as in any way objectionable or in conflict with the ethics of the profession, I think underline that his actions as a whistleblower have been accepted by his peers.
Indeed.
And his action has been regarded as ethically sound and correct, and to do exactly what a person in his position ought to have done. One can debate the methods, and one can debate the question whether the channels that were used were the most fortunate to use. But that's not what this application is about. The application is about the question whether Mr. Crichton's ethical standards were impugned by the actions that, or whether they were in actual fact demonstrated to be ethical by the mere dint of the fact that he did complain. And looking at the action of the LPC, they are certainly, as guardians of the profession, satisfied if they didn't lodge a complaint. There is no further complaint. And I don't think we need to concern ourselves further with the issue of protected disclosures, because they're not an issue before us at this stage.
Thank you, my Lord.
Well, let us see then whether there is a representative of Schumanns in court, and whether they wish to address us or not.
My Lord, it's Mr. Bushman speaking here. I hope you can hear me. My video quality is not of such nature that I would like to present myself. I'm also not properly dressed. We have not laid a further complaint. The reasoning for the affidavit was to put the facts as we saw it before court, to bring that to the court's attention and to leave it in the court's hands. We have not laid a further complaint against Mr. Crichton.
Do you intend to raise a further complaint against Mr. Crichton?
No, my Lord. What we had to complain about detention so that the court can make a proper decision as to the fit and properness of Mr. Crichton, and we leave it at that point.
Well, can I just ask you then, why did you not file this affidavit a week or two earlier? Why at the last moment?
My lord, one of the reasons, and that's not the only reason, is the fact that Mrs. Klein, who is the director that wished to bring this affidavit to the court's attention, had some serious health issues and was in hospital for the most of January and December. Only came back early January, and I don't think that, apart from that, I cannot address them.
Thank you, sir. But you give us, as an officer of the court, you give us the assurance that there is no further complaint before the LPC, and there will be no further complaint before the LPC.
I can give you that insurance. We have not laid a further complaint. We have laid the complaint that was addressed by Mr. Willis, and we do not intend to lay a further complaint. The only reason, as I indicated, was that this fact was placed before the court in order for the court to make a proper decision. As indicated also, we do not intend to oppose as such. We just thought, as officers of the court, bring this to the court's attention.
Thank you. Any further questions, Judge Miller?
Nothing further from me. Thank you.
Lastly, my lord, in closing, your lordship's description or articulation of the position we would rely on, and namely that Mr. Crichton, by blowing the whistle in these circumstances, demonstrated his character, an aspect of his character, and that is what I alluded to there earlier, my lord. Whistleblowing and making disclosures, my lord. In fact, one of the requirements of the PDA is that it's not done for any gain, personal gain. And my lords, the experience of whistleblowers is always very much the opposite. They take these steps, often well knowing that this is going to throw their life into turmoil for some time to come. That has been the experience of Mr. Crichton. In fact, it has played itself out in this court in our respectful submission. My lords, I submit the papers are in order. We'd ask you to admit Mr. Crichton.
Colleague Miller?
Yes, I think having heard Mr. Willis and also Mr. Bertelsmann, and having considered the affidavit filed, the other papers, I would support the admission of Mr. Crichton.
Yes, I think we have fleshed out the arguments as to whether the actions that Mr. Crichton performed and the effect thereof, and whether the implications thereof could constitute any challenge to admission or a finding that he's a fit and proper person. Against the background of the actions of the organization of his peers, I think there is no issue at this remaining about that aspect. And under the circumstances, it has been established that Mr. Crichton is a fit and proper person to be admitted, and he may come forward and take it.
Over to you, my sound is off.
In the debate between the court and counsel appearing for Mr. Crichton, Mr. Willis, that joining the legal profession is no easy matter. It is not something to be taken lightly, and it can and it will confront at some time or another all of you with very particular and sometimes severe challenges. Mr. Crichton faced an ethical dilemma of which you may or may not have been aware. He eventually blew the whistle on his own principle, and that was not an easy decision to take. Similarly, you may be faced with ethical problems in the relationship with your clients, or your colleagues, or your opponents, or your own appearances before the court. And we trust that in the best tradition of the legal profession and all its branches, you will not flinch from taking the ethical route, choosing the truth and the Constitution above gain, personal comfort, or worst of all, money. The legal system in South Africa and the legal profession is under severe strain at the moment, economically, but also because of its infrastructure and because of the regular fashion, the regular occurrence that the legal system is being attacked because of social, economical, and political issues that arise and that the courts have to deal with. Similarly, the courts are under attack for the same reasons. And it is all of us, every one of us in the professions, absolute duty to, in the exercise of our functions, display integrity, dedication, thoroughness, and to uphold the fundamental values of the Constitution. Unless we defend the independence of the courts, we may just as well say goodbye to democracy. And democracy is a precious, precious possession that our generation and the generation before ours had to fight bitter fights for before we eventually could inaugurate Nelson Mandela as our first democratically elected president. It is a precious possession that we dare not endanger and dare not lose. And every one of you has a direct personal influence to exercise and will exercise. If you perform your functions as a lawyer in the interests of your clients with integrity and dedication, you make a direct contribution to the continued existence of and the defense of democracy. We